A little bit about what the law says. We're going to ask you to repeal this ordinance and send it to a vote of the people. And let's go back and look at the advice you got. You were told it's possible that you could be held personally liable, and it's possible that the city could have a $230 million judgment entered against it. Well, we're going to provide more formalized presentations to you folks that show you that is out of the realm of reality. We've already told you that the city attorney did not advise you of the Local Development Act provision that specifically allows you to repeal the ordinance. Now, also the city attorney on the issue of personal liability did not advise you of Section 8.06 of the Local Development Agreement, which says you cannot be held personally liable under this TIF. You were also not advised of the issues of your errors and omissions insurance coverage. Under OMAG, which I assume, I don't know if the city has a different product, you were not advised of that. You were not advised of Carter versus Greenhaw, which says that under a contracts clause lawsuit, a party suing for violation of the contracts clause is not entitled to a money damages remedy. That is from the United States Supreme Court. That has been followed all the way up to the present day. We'll provide you with a formalized presentation that cites those cases. You were not advised that of the cases the city attorney cites, none of them support the notion that you can be held personally liable or that the city can be held liable for money damages. They said the exact opposite, and they also said that in this situation, it would not be a contracts clause violation. Now, what about, but there's still a breach of contract there under state law? Well, what you have to understand is that a party entering into contracts with the city is charged with knowledge of the limits on a city authority and a city's power. What are the limits on the city's authority? Well, one, Section 9.01 of the Economic Development Agreement says the city's obligation is to provide the TIF increment revenue. No other fund or revenue source of the city can be charged with the city's failure to do that obligation. And there's a case involving a county under the Local Development Act that we'll provide you with that's right on point to that. Now, we will also provide you, there also is, anyone entering into a contract with the city is charged with knowledge of this explicit repeal statute. Now, I think we've talked about and we reached a consensus that at some point it gets to the point where it doesn't make sense for the city to repeal. But right now it does. And there is plenty of law under Oklahoma. Does.